Hello and good afternoon, everybody. Thank you for joining. We have probably a few people in addition joining now. So I will just make some introductory remarks until we get hopefully everybody online. My name is Lori Baker. I'm the Director of Data Protection for the DIFC Authority. If you've joined previous webinars in our outreach series about the update of the Data Protection Law 2020, then you know who I am. If not, I report to the Commissioner of Data Protection, and I'm responsible for implementing the DIFC Data Protection Law into our lovely jurisdiction, and hopefully help you all understand what some of the key updates mean and answer any questions you may have to the best of my ability. Just a reminder that this isn't specific legal advice. It is guidance, and it's for your benefit to take away whatever you need to help you understand and comply. This will be provided and available on the Data Protection Commissioner's website. There are links throughout this entire presentation that will provide access to the website, access to the guidance page, and access to some of the other templates and things that we'll be talking about here. Also, just bear in mind, please, that if you have questions, I can take them possibly throughout if there's something really burning that maybe we just need a quick break to review something else or go back to one of the things that I said. Also, we will take questions at the end. Hopefully you can leave your questions via chat. This time we're doing GoToWebinars, so there is a larger audience. The format has changed from Teams, which used to be able to allow you to raise your hand and so on. This time, please I ask that if you do have specific questions, leave them in the chat. If we don't get to all of them today, I can still review them and try to answer others and perhaps even add them to our FAQs. Okay, so with that said, I'm going to move ahead in the webinar. Hopefully my page turns soon. There we go. Okay, so just a quick side-by-side again. You've all seen this if you've joined previous ones, but I think it's really important to keep reinforcing this. And you'll note that I've updated the notifications and applicability section at the bottom. It used to just be notifications. Now we're talking about applicability as well. I wanted to run through what applicability means and what sort of notifications processes you may encounter with 1 month to go until the law becomes enforceable. And I want to make a few comments about that as well. You'll note here that it says that notifications are still required for all entities to notify one way or the other. Yes, and that was essentially always required. If you went into our portal prior to the Data Protection Law 2020, you would have seen an opportunity to say, yes, I do report or process personal data. No, I don't process personal data, or my entity doesn't, I should say. And a few other options, amending details and so on and so forth. So it was always there. It's something that should be done. We need to know what you're doing. It was done during onboarding, or should have been done during the onboarding process prior to the law and prior to January 1, when the new entity onboarding process was updated to be fully digitized. You can, now that if you are an existing entity, update the service request section of the data protection notifications. You simply go back into the portal, you select the service request or data protection notifications, and you update your fields accordingly. So I will run through that in a little bit more detail, but I wanted to make it very, very clear from the outset that if the law is applicable to you, which we'll talk about momentarily as well, then you should be making a notification either way. Right, so we'll get into Articles 6 and 14 in detail, starting with applicability. Right, so with respect to applicability, it's covered in Article 6. Very, very straightforward from the outset is that under 6.3a, the Data Protection Law 2020 applies to all DIFC entities, okay? Not only financial services entities, it applies to all DIFC entities. So if you're non-financial services, you're a holding company, you're a prescribed company, you're any type of company within the DIFC, if you're processing personal data, you need to notify us. So that's how they're sort of tied together. But from the outset, this applies to all DIFC entities. So what you're going to consider there is, you know, what it is that you do within the jurisdiction as well when we get to the notifications piece, and I'll talk about that separately. So applies to all entities in the DIFC, but that have stable arrangements in the context of its processing activity in the DIFC. This is Article 6.3b. Okay, so that is a little bit further extending the reach of the DIFC data protection law. It's not something that you should take away as trying to be too much like the GDPR. I don't want to worry anyone or freak anybody out, but it does apply only in the context of the processing activity in the DIFC. Okay, so not in the jurisdiction that the non-DIFC entity is in, but with respect to the processing activity in or for the DIFC, including transfers of personal data out of the DIFC. So obviously, if there's data in the DIFC, and it's being transferred out, that's a processing activity. So even linking to the database that is based in the DIFC or otherwise processed in the DIFC, let's say, that transfer out should be covered by the law as well. And that agrees and coordinates with some of the other articles in the law that we'll get into a little bit more later, or that we've talked about previously as well, including international transfers. But it's really important to note that this is only really meant to cover entities that engage with a DIFC entity, for example, not on a one-off basis, ones that actually, are consistently processing activity is undertaken in the DIFC. You're a processor on the mainland, for example, and you have a relationship with a controller or other processor here in the DIFC. Only with respect to that processing does the law apply. So you're going to want to make sure if you're working with a DIFC entity, or the DIFC entity really should be responsible for making sure that whatever contracts you engage in, whatever agreements you make, whatever processing activities you set up, they are going to take into account the DIFC data protection law. And again, I say this a lot. You've probably heard me say it before. It's best practice anyway, really. The DIFC entity that this applies to is going to have to do these things under Articles 24 through 27 of the law, and including actually Article 23 as well if you're in a joint controller situation. But it's already prescribed by the law anyway that if you're the DIFC entity yourself, you're going to have to take these measures. But if you're a non-DIFC entity, it could potentially apply with respect to the stable arrangements in the context of the processing activity in the DIFC. So, and again, I note Article 14, notification of the Commissioner of Data Protection should be made and should be renewed on an annual basis. Right, so I want to talk about this two-pronged test, if you will, for Article 6.3b. Stable arrangements. A lot of people have asked what that term means since we have enacted the law. And that does come from European Union case law. It's making its way into almost every similar data protection law. It's basically saying any real and effective activity, even a minimal one, through stable arrangements may be sufficient to qualify to serve as an establishment of a relationship, gateway, or platform. I've added that, and I'll explain why under European data protection law. So with respect to stable arrangements, the threshold can be quite low. So whatever it is that you're doing in the DIFC, whatever that processing activity is, that it goes on and isn't on a one-off basis, that it is regularly conducted, that it is something that can be identified, pinpointed through IT or what have you as ongoing, that it's even made through contract, that could be enough to be a stable arrangement. So I have to add as well, though, that until we have a sort of test case in this jurisdiction, you might find that you make your own assessment with respect to what you think stable arrangements are and take the risk accordingly for your business. So we can't tell you one way or the other whether you have stable arrangements until we have an opportunity to do so, whether you ask us specifically to review it through prior consultation, whether you ask us specifically through a supervisory visit or a question directly to us. We're happy to try to answer to the best of our ability, again, from a regulator's point of view and not necessarily giving legal advice. And I've added the bits in parentheses about relationship gateway platform processing into, and I have here EEA jurisdiction because that's where the court was looking at the time, but think of it as here into the DIFC as well. This is sort of prevailing data protection law. And so you have to think of it in that way anyway. If you're covered by the GDPR, you're probably already considering this. And we have attempted to apply similar tenets within our law with respect to stable arrangements. It shouldn't come as any surprise then, if you do already comply with GDPR. And if you don't, or you have never even heard of it, or if you're a very, very local company and you have processors that you need to engage with in terms of agreements, you're caught by the DIFC law anyway, and you're going to have to ensure that whatever arrangements you have, whatever agreements you have in place is covering the DIFC data protection law anyway. So this shouldn't be too hard to meet or understand or get your head around. Hopefully it's fairly clear and you know about this from prevailing European law anyway. It's been around for about 5 or 6 years. Context of processing activity, again, I want to make it really, really clear. We're only talking about determining whether the processing activities are carried out in the context of the activities of a particular entity, the DIFC entity. I don't want to start throwing around the establishment clause again under GDPR. If there's any of you who know about that out there, we're not looking for you to register an entity here just to be able to say, that you're complying with the law if you don't already have one, for example. There is no way for a non-DIFC entity to register with us currently. And we realize that is potentially an issue that you might be asking, well, then how and why could it apply? It could, though, in the sense that the agreements with a DIFC entity, for example, as I said before, have to cover off the requirements of the data protection law anyway. But in any case, if you are a non-DIFC entity, and you're concerned about, letting us know that you're complying with the law, drop us a note, drop us a letter to the Commissioner of Data Protection's inbox, which you have the details for at the end of this slide deck. It will be posted, as I said, on our website, so you can find it easily, and it's all over our website anyway. But if you have questions about it, or you're concerned as it's a non-DIFC entity that may be subject to this requirement, then, or applicability, then you can, give us a shout and let us know. Whether such arrangements and context exist is an assessment which organizations need to carry out on a case-by-case basis. I can't stress that enough. We don't know what is happening in your organization, and especially because we don't know if there is an issue or an incident that needs us to sort of determine applicability, you're going to need to have some sort of documentation. It's in your best interests, at least. I mean, we can't determine for you what you do or don't do, but it makes sense to at least have documented either by agreement or in policies and procedures why it is that you've taken a decision that to certain processing the law applies or doesn't apply when you're dealing with a non-DIFC entity. Again, I can't stress this enough, DIFC entities, the law applies. You have to deal with it no matter what. It's when we're talking about non-DIFC entities that there could be a question. Okay, so I wanted to show you just briefly that we do have guidance posted about notifications in particular. So before we move into notifications specifically, you can see this is where you find it. Hopefully you can see my pointer. I could click on the guidance page. I think I will avoid that for now, but just note that again, you go to our guidance page, you'll be able to click on this particular notifications guidance. The DIFC website is hyperlinked here as well, so you can get to it easily. This is the DIP guidance website. And there's this example compliance checklist in DPIA. You can click on that. It will ask you to download this document. Just say yes or open it or save it to a location or what have you. It's run in the background of the DIFC website in any case, so it should be relatively safe for you. But in any case, you can download it and go through the checklist on one of the tabs to be able to determine whether or not you are up to speed with respect to compliance, especially around notifications and some of the other requirements within the law that flow from it. Okay, because the notification is mapped against the law itself. It's directly side by side of the relevant parts of the law that we're going to go through in this presentation, and should give you a good idea of what you're missing, what you're not missing, etc. Okay, so I wanted to show you as well with respect to guidance on applicability. You have other resources on the guidance page. Again, this is a hyperlink to the guidance page. This is a hyperlink to the general data protection guide. So just a basic playbook that shows you all the bits and pieces that you're going to need to worry about. We have assessment tools, right? So you have an applicability assessment tool. And if you click on that, which I will show you, and hopefully you'll be able to see it. You make sure that you can actually see it through audience view. Yep. Okay, so it's coming up now. It's taking some time to do so. But right. Okay, so now you can see here the applicability tool, and it asks you basic questions that you can kind of walk through to see if the law applies to you. If obviously, as I said before, you're a controller or processor incorporated in DIFC and you say yes, it doesn't go any further. You have to submit, and it tells you that the law is applicable to you. If, for example, you choose no, and then you say, are you a controller or processor incorporated elsewhere that has an entity that is processing personal data in the DIFC or for a DIFC entity as part of contractual agreement, arrangements, internal group structure, or other similar stable arrangements, including such arrangements that require processing resulting in transfers, you say yes. Again, you hit submit, and it tells you that the law applies to you. Okay, so these are just basic tools to help you understand and interpret the law. Again, they're not meant to be legal advice, but we do aim to help you to be able to make some assessments. And you can see there are other tools as well available on that page too. Okay, so we're getting into the detail here now, notifications process. This is an excerpt from our forms and fees page, which is hyperlinked here as well. Data protection notifications. This tells you very clearly, failure by entities to notify the Commissioner of Data Protection in accordance with the data protection law may result in the Commissioner imposing a fine in respect of the contravention as prescribed in Schedule 2 of the data protection law. The data protection notification is to be submitted through the DIFC client portal. DIFC registered entities are required to submit a notification as per the process below. So none of this has changed from what used to be on our forms and fees page. This is, again, as I said at the outset, all existing requirements that we basically just carried over for notifications. So for new entities, the data protection notification is part of the registration or incorporation service request. As you go through onboarding, you will see the data protection section pop up. You have to complete it one way or the other, and it will not allow the user to submit the registration or incorporation service request without finalizing the data protection notification, okay? And then with respect to existing entities, the notification renewal is part of the license renewal service request. So when you go in on an annual basis, you'll be required to update it. Okay. You can also go into the portal and make updates throughout the year as you like. So this is the duty to notify changes. You go into the client portal. If you have any updates or anything you need to change, you submit a notification to the commissioner through the portal using the service request data protection notification, again, as I said at the outset. So hopefully that's clear. I'm going to move on and give you a bit of a when, how, and what playbook, because I've gotten questions about, what is the deadline, and that is in air quotes if you could see me now, or what, are the requirements for notification. It's all set out in the law. And then there's the supporting regulations as well. There's no deadline per se, okay? If you're an existing entity, there's no real deadline. It's compliance or not compliance, okay? October 1st is the date from which the commissioner can enforce the law. Okay, so that means after October 1st, we're going to be enforcing the Data Protection Law 2020. If you're not in compliance with it and it comes to light, or we become aware of the fact that you're not compliant with it, we'll enforce it. I don't want to say it so bluntly, but in the end, if we don't know, we don't know. It's kind of like speeding out on Shakespeare Road. If you get caught, you get caught. But hopefully, and I'll reinforce this very, very strongly, you do just simply comply. We are looking at ways of ensuring compliance, and obviously enforcement comes with that. So I wanted to give you those sort of beginning remarks. But in terms of new entities, as I said, when it comes to onboarding, a new entity will complete the DP notification whether it thinks it processes personal data or not. And I put thinks in parentheses. You're processing personal data if you have information that identifies a living individual and you store it, you transfer it, you manipulate it in some way, you access it, or others can access it. That's all processing personal data. And it's written in such a way, the notification is written in such a way that it's asking, are you doing these things currently? I understand that new entities may not already be processing personal data. If you are processing personal data, consider that you may be already in terms of having employees, having stakeholders and shareholders, setting up suppliers during fit outs, and sort of opening up the actual stall or business that you have, your offices. You do process personal data, and it's not only in the context of customers and clients, it's in the context of anybody whose personal data you store and manage in any way. So 9 times out of 10, the natural outcome really is most entities will be processing personal data. A large portion of entities will be processing personal data. Okay, so what I want to point out, a couple of do not mentions here, is do not select that your entity does not process personal data. One, if it is only newly established and technically doesn't have such data to process yet. As I just said, it has employees, clients, suppliers, all of whom have personal data, and you need to be forward-looking. If you're just setting up, for example, a fintech, that you're just getting the technology up and running at first, but then you do start processing personal data on a larger scale, or more than just a one-off in terms of people who have already given consent or what have you, you can then notify the commissioner perhaps a little bit later, but not too much later. As soon as you know you're processing personal data, technically the regulations say you have 14 days to notify, as soon as you know, but I always just tell entities, get it in as soon as possible. That way you don't risk the 14-day sort of window that you have from when you know you're processing personal data. That's kind of a technicality. So in any case, don't select that you do not process personal data if you technically haven't been processing personal data yet. If you will or plan to, it's probably just better to notify. If you really don't want to just yet, or maybe you don't have the capital to pay the fee or what have you, that's another question, and that's my second point. Don't select that you do not process personal data because you want to avoid paying the notification fee. It's either compliance or non-compliance. As I said, if you don't feel like paying the fee, that's unfortunately a consequence of setting up a business, almost any jurisdiction really, and there is a fee associated with filing your data protection notification. But after that, it's virtually nil. I mean, it's not really a burdensome annual fee. And I know I can say that from my position. I don't want to spend your business's money for you and, determine what is or isn't acceptable amounts of outlay for your business. I mean, everybody has their own views on that, and obviously would prefer not to pay any fees at all, but unfortunately that's the cost of doing business. And it does go to presenting webinars like this for you, doing supervisory visits, providing clarifications and guidance, being able to interact with other regulators in other jurisdictions so that we can help enable business for you in places that you need to transfer data to. I mean, it's not just a sort of money in a scheme really for the DIFC authority. It's something to help support your businesses. We want to see our businesses be successful. The only way to do that is to support in some small way the regulator's office and being able to assist you. We're here to answer questions. We do make ourselves available. We hope it's not money wasted. But again, I really want to stress, please don't select that your entity does not process personal data to avoid paying the notification fee. If you're processing personal data, you're processing personal data. If you don't notify and you are processing personal data, it's a breach of the data protection law and enforcement action may be taken, fee or no fee. Okay, so just to sort of FYI for you, in terms of our offices, a list of all new entities providing notifications that they do not process personal data is sent to the Commissioner's office each week for review, and a sample of those may be contacted for a discussion to understand and support any misunderstanding about the law or how or why to notify. And notification gets recorded on the public register. So there's another benefit for you of notifying. It acts as a means of letting the world know on the most basic level how, what, and where personal data is dealt with by your entity. So if you look at any entity's registration on the public register that says that they've notified that they have processing personal data operations, you'll see details that are supplied as well about what that processing looks like. So if for nothing else, you have the opportunity to notify the world through our public register in some small way. Again, you can't necessarily call that compliance 100%, but it does help you sort of establish what your compliance looks like. Okay. For existing entities, please go back to the DIFC portal at some point soon, certainly by confirmation statement time, to review your entity's data protection notification. And again, whether you think you're processing personal data or not, quite frankly, this slide looks almost exactly the same as the previous slide. If it's only newly established, right, by the time you need to renew your license, you will have hopefully considered in your first year of doing business whether you process personal data or not. Technically, if you don't think you process personal data, you may want to re-examine that. And also, please don't continue selecting that you don't process personal data in order to avoid the notification fee. That just is not in your best interest to do so. So go to the available service requests and select data protection notifications. There are a number of new fields that will require adding new information. So even if you're an existing entity, again, there are new fields that you want to double check that you have completed or updated the old fields or what have you. So it's worth going back into the portal and doing your service request to update the information. Nothing has changed otherwise in terms of the process. The only thing that has changed is the fees. Unfortunately, they do go up a little bit, but we haven't raised them in a very long time in terms of data protection. So hopefully it's an acceptable amount, but unfortunately it is, again, a cost of doing business. The notification, again, gets recorded on the public register for existing entities when it's updated. You'll see an updated field hopefully soon. Certainly, I would hope by October 1st, you can see all the changes that have been made. And again, if you need assistance with your portal operations, when you go in and you do your updates and what have you, I can't really help you with that. It's going to just end up me sending you back to the Registry Services Help Desk. So just contact the help desk, please, from the outset. If your question is about the law itself and how to interpret it, I'm more than happy to try and assist. But if it's about the portal, doing your notification, anything like that, it's very, very difficult for me to answer because I don't have all the same access that the Registry Services team does have. So it just will save you some frustration to go to them directly. Okay. And with respect to enforcement, as I said, not notifying is a breach of the law, and there is enforcement action that we can take. It can range anywhere from directions and further investigations or reporting to other regulators to imposing fines as set out in Article 2. Guidance about fines and sanctions is available on our website again. This is under the Fines and Sanctions this is the Fines and Sanctions guidance link itself. And we, want to just comment here as well that we understand that the last 6 months have had a considerable impact on DIFC businesses. We'll be reasonable, obviously, on a case-by-case basis with respect to enforcement. We don't aim to take enforcement action on a regular basis unless it's some sort of administrative thing. There are things that we're looking into, for example, automating additional enforcement activities so it's a little bit easier and clearer. Again, some will be with respect to notifications review process. Those entities that have notified or not notified, I should say, that they do not conduct personal data processing, but it's almost impossible to say that they don't. We'll be looking into that. That's something that is an ongoing discrepancy, I think, within the jurisdiction, and for fairness for other entities that have received enforcement action or clarification. I think there needs to be a sort of basis set for all entities that could fall into that category but have said otherwise. So, for example, just to give you an idea, retail entities are the most obvious ones. They tend to process personal data on a regular basis. They have employees, they have customers, they have suppliers, loads of suppliers, some of them if they're restaurants or grocery stores or what have you. In our estimation, on a blind sort of thought process here, it would be really unlikely that a retail entity is not processing personal data. But if we can see from our reports that retail entities have said they don't process personal data, we'll be looking into those probably first, just to give you an idea of the thinking here. So I would again suggest that if you are a type of entity that probably does process personal data but have said that you don't or haven't notified yet, I think it would be in your best interest to do so. I mean, we are a small regulator's office. It's not easy to get to everybody's compliance status, but it's something that we are looking at getting our arms around as well. Okay, and any updates or changes will be communicated through normal channels. So I'm going to just take a quick peek at questions now, actually. Let me just see if I can expand this a bit. I can't. I don't know what just happened to it. Sorry, it's gone now. Questions. There we go. I found it. Uh-oh. Okay, so with respect to household processing under the DIFC law, that's a separate question. That's a separate part of the Article 6. Don't conflate stable arrangements or household processing. There's a question about that here. Stable arrangements is a whole separate section. Household processing, domestic processing, what have you, is addressed elsewhere in Article 6 and isn't related. It just isn't covered by the data protection law. Okay, so let me see if I can keep going. No, this isn't working. Sorry. 2 seconds. Try to open this back up. No, it's not working. Okay. So here's a question. Will the DPI apply to a branch or subsidiary of the DIFC entity, which is in any other jurisdiction? Well, again, only to the extent that there's some sort of internal agreements and sharing of data between those entities. Basically, if there's data that is processed or originated from a DIFC entity and there's a relationship with the other entities, say you have a back office that does your finance and payroll processing in a fully other jurisdiction, you're going to want to make sure that for that arrangement, you are applying the DIFC data protection law to the data that is being processed under that arrangement. So that's like any other data protection law in the world, really, though. And that's up to your business to ensure that you have those sorts of internal intercompany agreements. Not all businesses do. I think, again, that's good practice. Just putting my commercial or contracts lawyer hat on, I think just from a governance perspective as well, it makes sense to have those kinds of agreements written, and that it clearly sets out what you need to do with respect to processing data that is going from the DIFC entity to any other entity in the group. Okay, let's see if I can get any others. It's not expanding for me for some reason. Okay. There we go. Okay, so if a company is under group GDPR policy, will that be sufficient to be seen as being in compliance with the new DP law? It does go quite a long way. Again, we didn't really copy and paste GDPR, but there's a substantial amount of agreement with the GDPR, we'd like to think. You probably will be able to get away with compliance with the new DP law if you are applying the GDPR or the UK Data Protection Act, for example, or other similar laws in your group business. So I think you do need to double check certain specifics, like appointing a DPO. Again, under the GDPR, we have similar requirements. It's not necessarily mandatory in every case, but it is something that you may wish to do anyway, and you're welcome to do. If you have a DPO, for example, in another jurisdiction for the GDPR, the belt and suspenders approach might be to go in and update your data protection notification to list that person as well. Within the DIFC, for example. So just double check, maybe do a quick gap analysis. There's quite a lot in common though, and you're probably safe for the most part. So here's the next question. If I am a non-DIFC entity and have entered in a contract which is governed by DIFC laws, would this DP law be applicable? Yes. Effectively, the contract that is governed by the DIFC laws would include specific clauses around the relationship, written agreements or requirements under the Articles 23 to 28. If you want to review those, you can see exactly where, for example, you're going to have to incorporate elements of the DIFC data protection law. And it basically covers most of the data protection principles and the information that you would need to include anyway to have a decent data protection clause listed. Okay. Okay, this is more a technical issue, I think, unfortunately. I'm going to take one more question here, and then I'll jump back into the presentation. So We have a question here about a DIFC entity with offices, separate companies in New York and London. How does this affect the transfer of employee data with regards to payroll and personal data? Our payroll for all 3 countries is processed in London. What is required from us as a DIFC company with regards to processes and procedures in these jurisdictions? Yeah, again, I think I sort of touched on this briefly, but if whatever you're processing through your DIFC entity needs to be treated with respect to the DIFC data protection law. If you're transferring it out of this jurisdiction, bear in mind London, being in the UK, is a recognized jurisdiction as being adequate and having a similar or comparable law to the DIFC. So you shouldn't have any additional issues or struggles there with respect to additional transfer clauses that may be required. However, and that would be under Article 27. However, if you transfer to New York, you probably will have to worry about the Article 27 support or mechanisms for transferring that data out of the DIFC to New York. I think that's probably something that you're going to have to be concerned with anyway under the UK Data Protection Act for any data leaving the UK, for example. If the London office sends anything to New York, there's going to have to be certain clauses in place as well. So just think of it in that perspective. Again, if you have intra-company agreements, I would just say, make sure that within those agreements or attached to those agreements are the appropriate transfer clauses and the appropriate contracting terms within the body of the agreement itself. And those are all listed out under Article 24.5, and it should be fairly straightforward. Again, these are things that did come almost directly from the GDPR, so it shouldn't be anything really surprising. So I'm going to hop back to the presentation now just to go over a few key updates for you. Just to remind you of your obligations, I want to just do a quick review because, as I said, this is a one month away kind of review, and maybe you'll have additional questions as well. So the key obligations and primary updates that you need to be aware of probably sit firmly in Article 14 for the most part, as well as some contracting obligations, and 1 or 2 others that come later in the law. So they're throughout the body of the law, but there are certain actual compliance things that you want to take account of, and they're right up front, which is records of processing activities. You're going to need to keep records of processing activities, appointment of DPO and annual assessments if you appoint a DPO. So you're going to need to determine whether you need to appoint a DPO, and then that DPO has to submit an annual assessment with their annual renewal. Probably makes the most sense. I guess you can do it whenever you like, really, though. That's based on whatever procedures you set out, as long as it's done annually. They're conducting DPIAs, so you need to start thinking about having a template for that, which I said, is provided in the checklist document that hyperlinks within this guidance, this web presentation. You need to have cessation of processing procedures, so hand in hand with one of the principles around data minimization and accuracy and updating and purpose limitation is cessation of processing procedures. So if you're no longer required to process data, or you're requested to no longer process data, or what have you, you need to have certain procedures in place to put that data out of use, or to pseudonymize or anonymize it, or what have you. So you need to look at those articles. You need to have data processing agreements in place, as I said. Articles 23 to 28 cover all of the agreements obligations, and contractual obligations need to reflect data subject rights and additional controls around international data transfers. So those are things found in Articles 26, 27, and then 32 to 40. You're going to want to make sure that they're reflected appropriately, and it outlines, the law outlines all of this for you, mainly in Article 24 as well, but you can see in the specific articles what the data subjects' rights are, what additional controls are around international data transfers, whether to an adequate jurisdiction or a non-adequate jurisdiction. And then data breach response and notification procedures. That should be probably something you want to look into as well. Do you have any of those procedures in place? How do you respond when there's a data breach? Do you know who to contact? You might need to contact data subjects as well as just the regulators and the relevant regulators. We may not be the only one. It may be other regulators in other jurisdictions around the world that have similar requirements in their laws, and maybe even authorities, for example, like the police, if it's stolen data or lost data or what have you. But most importantly, the primary thing that we tried to weave throughout the law and our updates was to promote building a culture of privacy within the business itself. And this kind of gives you these relevant articles that I just mentioned, just so you can see where they are and where they're set out. Article 15, 16, 17, and 18 actually cover off DPOs. Article 20 covers off your data protection impact assessments. 22 is where we talk about cessation of processing. And then, as I said, all of the contracting articles are here through 23 to 28. I mentioned before, I don't have it listed here because it's a data sharing agreement article around government data sharing that kind of you might want to take a look at separately. And then privacy notices, that's something that's in Article 29 and 30. That's obviously your website privacy notices. If you have one available, you can set out a privacy notice there. You can use the DIFC privacy policy that's on our website as a model, if you like. And then Articles 32 to 40 talks about data subjects' rights, and 41 and 42 cover off breach notifications. Okay, so I just want to touch on this again. With the recent digital onboarding enhancements in the portal, you'll notice a difference to the data protection section itself. Since July 1st, the DP section of the portal covers off your business's compliance with essentially each part of the DP law. Before, we only asked about certain specific things. Now we have, again, aligned it to the law. It's a little bit longer to complete, not much though, and it's very straightforward questions. Do you have policies in place for XYZ, whatever part of the law it's aligned to? If we get a no answer, then it asks you why not, and you have to actually explain with some degree of clarity why you might not have something in place like a policy or a privacy notice or what have you. And it's as simple as saying, we're just getting started up, but we'll be back to update our notification. Amendments, depending on what type they are, are either no cost or I think a few dollars. So hopefully it's nothing, again, burdensome. You can update anytime you like. And I encourage everybody to keep the DP notification top of mind. I know it's just one piece of a larger business puzzle, but it is an important piece. And it really is good to, even just on a semi-annually basis, just check your notification and make sure it's all still accurate. If you don't, you certainly do it at confirmation statement and license renewal anyway. The idea, though, with our notification process and the DP section generally and how it's now written is to ensure that at a bare minimum, you can sort of print out or have in an online form a skeleton basis of a DP compliance program. It is compliance with the law. It's against every section of the law that counts. And you could look back at your notification and sort of say, okay, great, these are the bare bones that I need. You can look at the compliance checklist, as well, that is in the document that I mentioned downloads earlier from this presentation. We've gone out of our way, really, by the way, through your notification fees, to make sure that these things are covered off and making it as easy as possible for you. We'll also make enhancements as we receive feedback about the operation of the law, and especially with respect to the portal. If it's unclear or unhelpful, we want to know. We'll try to make changes as we go. And again, you just want to manage everything through the client portal as before. Nothing has changed there. It's just filling in additional sections that you might not have completed before. And again, I will reiterate, please don't say that you don't process personal data just to avoid paying the notification fee, because again, it's either compliance or non-compliance, and non-compliance results in fines, which are a lot heftier than the basic notification fee. And then finally, as always, questions for the Commissioner's Office are always welcome. We'll try to answer them as best as we can. We have a lot of questions that come in and don't always get to everything immediately, but hopefully you can understand that and bear with us while we answer the many questions that we do get. You also are encouraged to take advantage of the consultation period for processing that your organization is considering. We're happy to talk with entities about what they're thinking about doing, whether it's high risk or not, or what have you, and whether we have any tips or things that we'd like to see. We can also do voluntary supervisory visits. I've gotten a few requests for those, and I'm really happy to do them. Whether it's virtual or in person at this point, we're always happy to work with you on that. And then just generally, you want to review your business's data protection status currently and update it as needed, both within your organization and on the portal to align with the law. And again, I wouldn't say there's a deadline per se. The law becomes enforceable from October 1st, 2020. But in terms of by when it should be done, my view is always ASAP. Your data protection status for compliance is as it is today. It's a live operating thing. So you can aim for October 1st, 2020, but I encourage you to do it the sooner the better. Certainly, if you haven't updated or even done anything with respect to compliance with the law after October 1st and it comes to light for the Commissioner's Office, there could be enforcement obligations on our part. And that's it. You can see here at the bottom of the page, the Commissioner's email address. That's our general email address for queries. Please, we check it as often as possible and try to get back to everybody as quickly as possible. All right, so there are still plenty of questions. I'm going to go through and try to answer a few more at this point. In case of an organization, can it make it conditional to join it by accepting all terms and conditions, which includes the acceptance of sharing data with anyone for any purpose? Example, like Gmail, while creating a Gmail account, user needs to agree which terms and conditions, which includes that information, can be shared with sponsors, etc. I mean, that sounds more like a question about a privacy notice and what you post on your organization's website, about your terms and conditions, your terms of use, signing up for something like that. You can't obviously take away people's rights. You have to provide them, for example, under our law, under Article 32, you have to have a notification about the right to withdraw consent. You have to say this, probably even in contracts would be useful to do. So yeah, I mean, that's your own terms of use kind of question, I think, more than anything. And if you take legal advice for writing your terms of use or terms of service for your website, or if it's a bog standard kind of PDF template for signing up for a service that can't be altered by your clients or customers, that's something that you need to draft, I think, probably with appropriate commercial contracting or terms of use legal advice, and making sure that you're not taking away data protection rights in particular through doing so. Liability needs to be addressed, that sort of thing. But generally, I mean, yeah, I think it is possible. It's done regularly. If you look just at Facebook's terms and conditions and Google, as you said, Gmail, other big organizations like that, those are the kinds of things that they do on a regular basis. And in fact, Facebook's terms and conditions are being updated October 1st, by the way, just as an aside. Right. Okay, here's a good question. As the company notifies of the data processing under the notification, how detailed must the information be? Can the submission of categories of data be sufficient? I mean, there's the bare minimum that we ask for, which is you can like sort of just drag and drop whatever categories we've set out. If you want to add categories that you think we've missed, I think there's an option for other and free text. The more detail from our view, the better for you and for us. We only publish a certain amount on the public register anyway. I would advise not including actual personal data of people in your notification unless it's to identify your data protection officer or any other specific stakeholders. But yeah, I mean, details are always great. We don't ask for anything extensive as long as it's clear and substantiates your notification. It's up to you to decide the sufficiency of it, I think. Okay, so the next question is sharing employees' info and clients' KYC documents with sister companies' HR and onboarding team in the UK under the confines of the new DP law for HR and onboarding purposes only. Yes, there's no carve out apart from domestic purposes or what have you, as outlined in Article 6 about applicability. It applies to any processing that you do. So if that's processing personal data, then that's how you have to prepare your compliance position. And I would note as well that very often KYC data includes things like criminal records and whatnot, and that would be a special category data that you need to take extra care with. Here's a question about being a holding company. We are just DIFC holding structure entity established for the sole purpose of owning DIFC entities. I think we can select that we do not process personal data. Again, yeah, I mean, I've worked with holding companies that on reflection decided, yep, they do process personal data for whatever it is specifically that they do. But if it's just a non-regular basis sort of processing, or it's just a few stakeholders, if you're confident that in your decision to notify us that you do not process personal data is accurate, then that's your choice. Like I said, it's not going to apply in every case, but a large majority of entities will process personal data in some way or the other. It is the situation though, however, obviously there are certain types of entities that are just even financing structures. They're probably not processing personal data, and that's understandable. But let me just put it this way. If you can justify to the commissioner's office that there is no processing of personal data, or it's so minimal that there's no risk to the data subjects, or they're completely aware and they've consented, or whatever it is that you think you can do to justify, or if you take legal advice to be sure, we're willing to listen to that. It's not out of the realm of possibility. My proviso about selecting we do not process personal data is really more about avoiding the technicality argument and avoiding the we don't want to pay the fee argument, because that in either case you could still be on the hook for enforcement. But if you're reasonably confident that you really don't process personal data, you can take the risk as you like for your business. So the next question, does Article 6.3b apply to consulting advisory firms helping DIFC entities in internal audit, compliance, and advisory activities? Yes, again, in the context of just the processing that it does, within that arrangement, it could very well be. If it's just a one-off, I think the law actually does specifically state that it's not sort of for one-time processing, but it's for regular stable arrangements, then yes. But again, in that situation, you're probably going to have a contract with the non-DIFC advisory firm or consultancy or what have you anyway for providing services. And if you're a DIFC entity contracting with them, you're probably going to include our data protection requirements in your contract anyway. So it indirectly sort of operates to apply in any case with respect to the services that are being provided. And that's all it's really, again, meant to apply to. With respect to services being provided, to a DIFC entity with respect to accessing data that's housed in DIFC or is in a DIFC data center. You could stretch it out really, really far and even say, scraping or bots meant to pull data from our public register on a regular basis. Could theoretically be a stable arrangement. Again, we don't have the case law to prove that yet, and it hasn't been tested. I'm just throwing out, sort of extrapolation ideas that I don't want anybody to panic about. But just think about it. This is, again, what we've always said. We're a small enough jurisdiction. We have the flexibility to be able to examine these questions in a little bit more detail should they come up. If anyone raises them to us or what have you. So, we're happy to talk about it. But again, I would say that you need to look at applicability, not parsing it out into any particular function or type of processing. Processing is processing. It's very, very broad, again, under our law, if not other globally accepted data protection laws. Right. I'm reading one more question. Let's see. In your guidance, the administration of licensing or maintenance of official registers is treated as processing. Does this include maintaining register of directors of an entity, which is a prescribed company? Potentially, yes. I mean, yeah, there is personal data on the register. Again, as I said at the outset, having just a few people associated with the entity and processing the personal data and applying the data protection law and the notification process to that, that's your call to make with respect to whether or not you think you process personal data on a regular, stable sort of basis. The law does apply, though, to the DIFC entities. And again, a natural sort of outcome is to say that you do process personal data and that you should notify accordingly. Again, even if you have an office here and suppliers, and it just depends your risk assessment on how far the processing goes and how much there is and how risky the processing is, to be honest. You want to look at all of that. If you're comfortable that the register of directors is, sort of outside of that scope, or you can justify it, let us know what you think and your justification for it if we do happen to come across an issue. Here's a good last question or two. I'll try to answer these quickly because I think we're running out of time, or we have run out of time. One more then, what is the meaning of processing personal data? You can look in the Data Protection Law Schedule 1, Article 3. It defines processing. It's no different from any other definition under any other data protection law, though. It's accessing, transferring, storing, manipulating any sort of operation that is performed on data. Having personal data information because of various contracts signed could be processing personal data, yes. If the contract is around collecting, storing, accessing email address maintenance, you have a whole address book, you're technically, you could be processing personal data in that regard. You just need to make a determination as to what you're doing with the data in order to determine whether or not you're processing it. So, but there's a lot of literature out there that sort of supports the idea that processing is any kind of accessing, use, manipulation, or operations performed on personal data of any kind. And personal data is extremely broad as well. It's anything that identifies a living individual. So with that said, I'm going to sign off at this point. If anybody has any further questions, we can try to answer them separately, or as I said, you can contact the commissioner's email address below. Hopefully this was helpful to you. And again, we've got a month before it becomes enforceable, the data protection law. Just bear that in mind in terms of your updates and notifications. Thank you.